Hello. Hi, Felicia. Hmm. You're muted.
Okay. Hello, Mahani.
Hi. Yeah.
So good to see you. We just had some hitches, but I guess we're now good to go.
Okay. Okay. So we will just start, yeah, because there's no time. Are people waiting already, or do we have to wait for like 5 minutes?
Do we have to wait a bit? Let's give it some minutes because you need to even about 11 people are in. Okay, do you think we should wait for a couple more minutes or we should just dive into it? But we need to introduce Mahani, and I need you to show her profile, right?
So are you going to have this presentation?
We're live now. Yes, and yes, the presentation, immediately you're ready to start. It will be shared on the screen.
Okay. Okay.
Yes.
So I'm ready.
I know you've had a hectic couple of days, and yes, hello everyone. Thank you so much we want to warmly welcome you to Imagine Africa Trustees webinar on Islamic Trust and Estate Planning. Our speaker is none other, and I'm sure you've already seen in the flyers and all that we sent out, is none other than Mahani Amin, and she is here. We truly appreciate her joining us and agreeing to give us this talk. And I'm excited, I don't know about all of you, because she's actually an authority on Islamic trust and Islamic estate planning. You're here to share her profile. So anyway, I think we'll just, thank you so much, yes. On the screen now, we have Mahani's short profile. The profile is actually, her profile speaks much more than this, but I'll just dive into it. Mahani Ahmed Amin is the managing director of Metropolitan Law Firm. It's a full-service law firm with its headquarters in Abuja, and is renowned for Islamic banking and finance practice. She founded Metropolitan Law Firm in 2008 with the consultancy outfit known as the Metropolitan Skills Limited. After obtaining her qualifying certificate to practice in Nigeria, Mahani served in both public and private sector capacities, including her appointment as the Senior Special Assistant Technical to Minister of State, Federal Ministry of Commerce and Industry in 2009. In 2020, she was also appointed as the Senior Financial Flows Consultant for the LINKS program initiated by the Department for International Development in the United Kingdom, which is now called the Foreign Commonwealth and Development Office, FCDO. Mahani has advised corporations, government agencies, and regulators on key transactions, ranging from corporate securities, mergers and acquisitions to project finance. Some of Mahani's landmark Islamic finance transactions include the first corporate Sukuk issuance in Nigeria by Family Homes Fund, and the first Tier 1 Sukuk program in Nigeria by Taj Bank Limited. Indeed, her immense contribution to the advancement of this niche area in Nigeria through promotion and education earned her recognition as a subject matter expert on Islamic finance and estate planning industry. Mahani is an alumnus of Bayero University. That's to her. She's actually a member of reputable professional institutes such as Institute of Directors, the Society for Corporate Governance, the Non-Interest Finance Association of Nigeria, and the Association of Investment Advisors and Portfolio Managers. She also sits on the board of the Nigerian Exchange Limited and 117 Capital
Felicia, don't you think you should
Limited
we should
e-text under a very
speak
tight schedule, and and we are eager to have her start this webinar
Felicia,
on
why
Islamic
don't
laws and
you
Islamic
just
learning.
skip
Thank you.
the introductions and let's just dive into
I agree.
it? Okay, good afternoon, distinguished participants. My name is Omahani, she has rightly said, and I am going to go through what Islamic estate planning is generally. So I'd like to start by the reasons why, apart from all of these things about my profile, why I delved into Islamic estate planning mostly was because it has something to do with me. I had experienced it first class, I would say. When my father died, he left a will, um, which stated a lot of things that needs to be done and needs not to be done and all that. But because of the lack of knowledge we had, even at that time, I was a kid, and all of those people that were involved did not really have that knowledge of Islamic estate planning. None of it was followed. And so at some stage, they went to court and all that. Even the judges do not really have an interest in estate planning. They didn't understand it. And so it was just a lot of chaos and all that. So I got interested in it, and I thought that it would be worthwhile to share the knowledge with everyone, so that you won't have to face what we faced as small kids. Thank you very much again. And I'll start um, with the introduction. So I'll start with what is estate planning generally. Estate planning generally is the process. Okay, you want to share my screen? Oh,
Yes,
great.
yes, yes. For the benefit of the
Okay.
attendees, yes. Thank you.
Okay, so we'll start with the first slide.
Can you see the screen, Mahani?
Yes, I can. Thank you. So
Okay, fine.
Islamic estate planning, like we said, is the process of devolution of one's estate for the purpose of achieving a preset goal after one's death. So this estate planning has to happen when one dies, not when you are alive, as in it takes effect. So you start planning for it during your lifetime, but it takes effect when you're gone. Will also talk about in due course. So the essential difference between Islamic estate planning for non-Muslims and Muslims lies in the fact that Muslims are subject to the Sharia Islamic law. And this has been affirmed, like I mentioned, in the case of Jiddun versus Abuna, where it was held that when a Muslim dies, his heirs are permitted by law to appoint a person learned in Islamic law or to share his estate among them according to such law. And if subsequently the matter is taken before the court of law, the court will enforce the sharing provided it confirms with the law. That means it confirms with the Islamic law of inheritance. Usually people write their wills and leave their wills, but if it does not conform with Sharia law, that's if it has been established that the deceased lived as a Muslim and he died as a Muslim, even if he had a different version of what he would want his assets to be, if anyone complains, of course, if any of his heirs is not happy with it, then the courts will decide that it has to be shared according to the principles of Sharia, because he lived his life as a Muslim and he died as a Muslim. So this is very important for all Muslim clients to understand, that even if they want to, because we had clients that would say, I had one particular client not long ago who says that, oh, she wants this and this and this to be done. while she's alive, and after she's dead, she wants this to be done. But I told her it's not possible, because by the time you're gone, you don't have any authority over what you have left. It has to be shared according to the Sharia. So while you are alive, you must do what you have to do. But of course, even that, there are exceptions to the general rule, because you can't be 90 years old and then go on a spree of giving this and that and selling this and that. They won't even allow you to do it, because you are supposed to leave assets for the people that are inheriting you. So you're not allowed to do certain things. You have to, they will say you are not in the right frame of mind. So I'm trying to be as practical as
Yeah.
as possible for people to understand. Like if you're a 90-year-old and you decide, oh, I want to give Umahani $1 million from my from my account, and then this guy has like 15 children, 30 grandchildren, and all that, they will be like, wait, what is wrong with this man? Is he out of his mind? So at a certain stage, you're not even allowed to make any investment or do anything, depending on your state of mind. Yeah.
Yes.
So the next.
If I may jump in here, Omahani, yes. Which is, I know down the line at the end of your presentation, I'm going to talk briefly on the regular trust. And I just wanted to chip in here that for a trust that is not Islamic, which we handle, the first thing we would ordinarily do is that they would, if the person, of course, is advanced in age, like you said, there will be a certification from a medical doctor confirming that he or she is of sane mind and good health when setting up the trust, even if it's a testamentary trust. So that has to be in place, you know. I just wanted to chip that in. Thank you.
Yeah. So in Islam, of course, that test has to be taken to understand that you are in the right frame of mind. I'm not. So I'm going to say that the English trust is predicated upon the Islamic law of trust. So if you look at what the English trust is, it's the same thing. It's just that this is Sharia compliant. It's just like doing Islamic finance. When I say it's just like a football game, everything is acceptable except that which is specifically prohibited. So the main ingredients are the same. It's just that, of course, we have some basic principles, and then it goes back to the Quran, the Hadith, and when it's not there, then the Tabi'un, and four schools of jurisprudence, and like that, until the recent jurists who can make analytical deductions and all that. So, so the difference between the English trust and the Islamic trust is that this is rooted in the Quran. The Islamic trust had started long ago before the English trust came about. So most of the ingredients in the English trust are based on the principles of Islam. Okay, let's continue.
Thank
The
you.
next, okay. So we're talking about the concept of wealth in Islam. In Islam, go back to the last slide, please.
Is this the slide? Or the previous
Yes,
one?
yes, this one.
Okay, great.
So I was going to say that the concept of wealth or mal from an Islamic perspective is that the owner of the wealth is not the ultimate owner of this wealth. That your wealth belongs to Allah, the Creator, who gave you this wealth, and then you have to. So you're just holding in trust for Allah, and then Allah has directed that you must do certain things with your wealth, and you must follow these instructions as it is stated in the Quran, and also the other principles of Islamic law, and the Hadith, and the rest of the books or notions on Islamic estate planning. So it is provided that the owner of this wealth is responsible to the creator, and in turn, he is required to utilize this property or this wealth responsibly for himself, for his family, and his community. Because it is agreed that it is not because you have worked so hard or because it is your effort, it is Allah that gave you that wealth. And so you must do with the wealth according to what Allah has prescribed that you should do. Hence, the Islamic estate planning process must ensure and take into account that the financial affairs of all your legal as your beneficiaries are adequately addressed. That was why I talked earlier about you not having the mental capacity to take care of your wealth, then it will have to be revoked, really. Like selling off assets or giving gifts when they see that you're not in the right frame of mind, then you're not allowed to do that. The next slide, please. So Islamic estate planning is very crucial in the Sharia, that because it seeks to protect and promote 5 values, namely your faith, that is you believe in the oneness of Allah, then your life as you live, and then your lineage, that's your family, your family where you come from, and then the property and that you have been able to acquire through the means which were provided by Allah, and this validates the measures for their presentation and preservation and advancement of this world. So, like I said, there's faith, life, lineage, intellect, and property. So when you go through that, then everything you do will be Sharia compliant, especially the estate planning. And we have estate planning tools that are effectively applied, and the process usually upholds and promotes and preserves the aforementioned Islamic values we have mentioned before. So we have the objectives of Islamic estate planning, which are providing the funds for the burial expenses and debts, and ensuring efficient control and management of one's assets, and then ensuring that the assets get to rightful heirs in accordance with Islam. So when one dies, of course, first of all, your funeral expenses must be taken care of. And then if you have debts that you owe people, it has to be settled. Then, of course, then it comes to if you have left a wasiya, that is a will to say this is how this should be done and this is how this should be done. Then that was mentioned, then it would have been sorted out first, then your Quranic heirs will now come in play. So the rights and entitlements of each Quranic heir are clearly set out in the Quran. And these verses form the part of the law of Fara'id, that is the law of inheritance. We have Surah Al-Nisa, verses 11, 12, and 176. From these verses, you can be able to deduce that Fara'id is applicable upon the demise of the Muslim, and that entitlements will be distributed after honoring the legacies and the settlements of debts, like I had mentioned earlier. That is the burial expenses, the loans and debts owed by the deceased, the unpaid zakahs, and of course kafara or pledge. That's if you pledge to take someone, for example, to school, you've been paying for the education of someone, then even that has to be settled first before you go into trying to divide whatever is left out of the person's inheritance. And kafara, if you pledge again to say that even if I die, I have promised that I am going to take Umahani to Saudi Arabia for Hajj, then that must be fulfilled again. before before the inheritance are shared. From the hadith of Ibn Umar, he narrated that Allah's messenger, peace be upon him, said, "It is not prudent for a Muslim who has something to give a bequest, that is to give wasiyah, to have it for 2 nights without having his will written regarding it." So it means that for every Muslim, and this extends to the life of a Muslim, if you go out, for example, if I am traveling tomorrow, perhaps maybe to another country, I will tell my family, if I die today, please, this should be done, this should be done. This forms part of wasiya. If you do that with witnesses, then, and you happen to, of course, Allah calls you, then first of all, this one will come and say, "Oh, I have left this for." Umahani had said that when she dies, this must be done. This must be done. Okay, and another witness corroborates that this she had said that. So even without a written will, these are usually taken into consideration. You have told 1, 2, 3 people who people believe are credible people who can pass through the test of people with integrity. Then it will be said, yes, you had said you will do this and your wishes must be carried out. But usually, it's better for you to write it, because you find out that people will want to leave a will, or they owe some debts and all that, and then their families will come and say, "It's not us that are owing, it's the deceased that is owing and he's gone." If you like, follow him to the grave and collect your money, for example. This has happened in real life situations when people come to say, "Okay, this deceased owes us money." The heirs will say, "No, they are not paying." But if you leave a will and then there's a trustee and all that, you plan your estate properly, like you try to do for clients, then that saves like more than 98% of anyone's problem. The other problem would be that if one leaves a will and then one of the heirs says, "I do not agree," then it goes to court. And if the court determines what happens, then it means that the life of that person will be looked at. Did you live as a Muslim? Did you die as a Muslim? When it has been determined, then it will be, your inheritance will now be shared according to the Sharia. And then, of course, fulfilling all obligations if they are legally allowed to be followed. Then this will be followed. And then the next slide is, okay, Islamic law sets out strict and rigid inheritance rules. And that determines how a Muslim's estate is to be distributed between the deceased heir after his demise. The law further limits testamentary freedom to 1/3 of the deceased estate after the deduction of funeral expenses.
Sorry, Mahani, we lost you for some minutes. Is it up to a minute? Not quite, but we didn't hear what you said last.
Okay, I was saying that Islamic law is very strict and rigid. It has strict and rigid inheritance rules, which determines how a Muslim's estate is to be divided after his demise. But he has the testamentary freedom to do as he wants with his 1/3 of the asset.
Only
of
1/3
whatever he leaves. So yes, 1/3 of whatever he leaves. He's allowed to do whatever he wants with it. He can give it to his neighbor. He can give it out in charity. He can do a lot of things with it. But the most important thing is your heirs are not entitled to this 1/3. So it has to be the people that you are not that are not your Quranic heirs, for example. If someone has probably their niece and nieces whom he's looking after, he can give them out of the 1/3. but the rest will be shared, the residue will be shared to his heirs according to the Sharia. I have a live example. Someone I know, a family I know who lives in the US, the woman is Syrian, both her and her husband, but they were not practicing Muslims. And so the wife was now became a practicing Muslim. But before then, they had adopted a Chinese girl as their daughter, and they have other children. So now they want everything to be done according to Islam. And they were talking about planning their estate. Now they said, okay, they do not want the girl they adopted to feel bad about them giving their children, their biological children, whatever they've left, and for her to feel bad. They don't want, because she doesn't know anyone except them, they're her parents. So I told them that they have the right to give her 1/3 of whatever they leave. From the 1/3, they can do whatever they want. But they also said she will be emotionally not okay, because then they will tell her, the lawyer will tell her, oh, because you're not their biological daughter, so you are entitled from that which they had promised to give you. And they don't want her to be traumatized after their death. So I said to them, the only alternative will be that since you are in your rightful minds, you have the testamentary capacity, you have the right to be able to gift out whatever you want, even if you want to give out all of it, even though Islam frowns at you giving everything you own to people, leaving your heirs to suffer. But they can give all their children in equal shares when they're alive. And that was exactly what they did. So they shared their assets um, to all of the children while they were alive. And as Muslims, gift is complete. You cannot say, oh, I've gifted Umhani this, but I will take this house, but what during my lifetime, I'll take whatever rent that is accrued from that place to be able to use. But when I die, the property now goes back to her as a gift. Islam does not allow that. If you give me your house during your lifetime, that gift is absolute. You cannot, because otherwise, if you take part of the usufruct, then it means that it has devolved back to your estate. And after one dies, it will be shared according to the principles of Sharia. So going back to the heirs, this can be divided into 3 categories: the Quranic heirs or sharers, the agnetic heirs or the residuaries, and then the uterine heirs and the kindred and distant kindred. Go to the next slide, please. So the Quranic heirs or the sharers are those relations of the deceased whose shares have been determined by the Quran. Their share are in order of preference and in succession, and is fixed under the Quran. So you have 12 of them: the husband, the wife, father, mother, grandfather, grandmother, daughter, son's daughter, Jermaine sister, that's your sister from the same parent. Remember that Islamic family law is that of polygamy. So you find out that you have a relation whom you share the same parents with, and then you have one whom you have the same father with, different mothers. You have one whom you have the same mother, but different fathers. And then you have a brother who you have different fathers, but the same mother. But these things, this inheritance goes in order of priority. We'll speak about that shortly. Next slide. So primary heirs among the Quranic heirs include the father, the mother, the husband, the wife, and daughter. and they are never ever excluded from inheritance, no matter what. They're always part of the inheritance, and their entitlement to inheritance is subject, of course, to the rules of fara'id. That means if one excludes the other in order of priority, that's when then agnetic heirs are common. They're commonly consistent of male and some female
Sorry, man, if
relatives
I may
that
jump in,
inherit.
here, man, I don't see son there. How do you
You
explain
said
that? I don't
exactly.
see
I'll come
son
to
there.
that.
It's father, mother, husband. Okay, so
Yes,
down the
yes,
thing.
yes. I will come to that. I'll come to that. No, a son is not mentioned, but I have
Yeah.
also spoken about that in one of the slides. So we
Okay.
will come to that. I
So
know
we should be
everyone
patient.
is always
Everybody be
very
patient.
curious about the son not mentioned. Yes, yes, yes.
Mhm.
So like I was saying, the entitlement to inheritance is subject to the rules and of application of the fara'id. Then the agnetic heirs commonly consist of male and sometimes female relatives that inherit as residuaries after the share of the Quranic heirs is distributed. That's what I was talking about as in the order of priority. So if one dies leaving his relations, the consanguine and the uterine. So the uterine, the one who has the same mom, same dad will inherit first, followed by the one who has the same dad but different moms. Then the one who has the same mom and then different dads will inherit last. So the one who has the same dad takes priority over the one who has the same mom as it is, because Islam believes that the affinity of the father is stronger, not more important now, stronger than that of the mother. But but then again, Islam had encouraged that you follow your mother, and your mother first before your father. The Prophet had mentioned 3 times when a companion had asked him who should he follow first, his mom or his dad? And he said, my mother, your mother. He asked again, he said, your mother. For 3 times, he said, your mother. Then the 4th time, he said, your father. So this also institutionalized the importance of a mother in Islam, which is much more than that of a father, where they say for a man, if his mother raises her feet, that's when he will enter paradise. That's how important it is for the avoidance of that. So the uterine heirs or kindreds include any blood relation who is not a Quranic or an agnetic heir. And this is explained in this table. Okay, if you share the slide. According to the Fara'id, each heir is entitled as follows. So if the heir is the husband and then the wife leaves children, then he's entitled to 1/4. That's a quarter of the assets of the deceased. The wife does not have, if the wife does not have children, then he's entitled to half of what his wife has left. And for the wife, if the husband leaves children, she's entitled to 1/8 of the asset. And if the husband does not have any children, then she's entitled to a quarter. And for the father of the deceased, if the deceased leaves children, he's entitled to 1/6. And then if the deceased does not have children, then his father is entitled to 1/6 and the residue of whatever after fulfilling all other obligations. Then the mother, if the deceased leaves children or the deceased leaves no children and more than one germane sister, then her entitlement will be 1/6. And if the deceased has no children and only one germane sister, then her entitlement will be 1/3. And so also, if it's the son only, he gets the residue. If he inherits with the daughter, they inherit in the ratio of 2 to 1. The son has 2 portions and the daughter has 1 portion. And then, of course, if the daughter is the only child, then she has half, and then half of the asset is now taken to go to give out to the other heirs who were not his immediate family, like his sisters, his brothers, like I had mentioned in that order. Then in the absence of a father, that's a uterine brother and sister. That's if you are the same parents with the deceased, same mom and dad. Then in the absence of a father, brother, sister, and child of the deceased, and are the only Quranic heirs, then they get 1/6. And in the absence of father, brother, sister, and children, they get 1/3. So with this, we will go into, with this explanation, I hope everyone has understood the background for inheritance in Islam. So the next thing we're going to discuss now will be the Islamic trust. And understanding Islamic trust, one requires the understanding and concept of the Islamic estate planning. That was why I had to have a background for people to understand how do we get into getting a trust done. So generally, a trust is a relationship whereby property is held by one party for the benefit of another. It is created by settlor who transfers some or all of his or her property to a trustee who holds that property for the specified beneficiaries, and in some instances transfers it to the beneficiary upon fulfillment of conditions. Felicia, is that not so in the English trust? Is it not the same principle?
It's the same principle. That's the basic
see what
principle
I'm
of the
talking
trust, and there must be, yes. So interesting. I'm listening, and I've just been educated on Islamic law concerning estate planning, but I see similarities with the English law, which is the background of the mainstream trust that we handle. Lots of
So, and
similarities.
remember that Islamic law has been there before the received English law.
That's debatable because trust.
Okay, let's just have this conversation offline, I'm sure. Okay, so the conditions are amana and wadia are common expressions of Islamic trust. A trust may vary in type. Examples would be waqf, that's the endowment fund, hiba, amana, etc. So hiba is gift, waqf is endowment, and amana is to put something in trust. So the revocability of a trust is largely dependent on the type of trust. And generally, there's a relationship whereby the property, okay, sorry, I have to go back again. So trusts are declared in one's lifetime.
Do
And
you want
then,
us to go back to the previous slide?
yes,
Okay.
please.
The previous slide. Is that it? Is this the slide you want, Mahani?
Oh, okay. So yes, this is the slide I'm talking on. So generally, a trust is a relationship where, of course, the property is held for the benefit of another in trust. Like we said, we have the waqf, that's the endowment fund, the hiba gift, and then the amana, that's also another Arabic word for trust. Usually this amana happens when between friends in the olden days, when you're living, you will say, even if I die, my friend, this is that knows this thing, this is, you will call him. So whenever one dies, immediately the people who are very close to him will come and say, oh, he has left this, he has done this, or he bought this, and this one owes him, oh, he owes this one. So your friend in Amana will be able to say exactly what you have left, and you too will leave all your family and for him to hold in trust for you. So anything you ask, the person will say, this is amana, I cannot touch it, like that. You give me money to hold is amana. Whenever you come, I can't change it. If you give me 1,000 naira notes, when you come back, you must see 1,000 naira notes. That is the importance and how strict amana is in Islam. You must not touch that does not belong to you. It's kept in trust for you. Um, trusts are declared in one's lifetime and are typically irrevocable because the rules of Fara'id do not apply. That's the rules of Islamic law of inheritance do not apply to that trust. An example of this is Waqf. Waqf is an endowment fund. Okay, so the estate, for example, where I live is an endowment fund. The owner of the trust fund did this trust in the name of his mother. It's called Mariam Education Trust Fund and is a family trust fund. Is a typical example of a waqf. So this estate where the man has all of this in trust. He has his trustees, board of trustees, and every year they get rent, they give it out in charity. And of course, again, is a family trust. So each and every member of his family is entitled to go to school wherever they want in the world, and the trust will pay for it. If you are in Nigeria, I remember four of your children can go to school in Nigeria. If they're abroad, then two of your children, and the trust will pay for it. And this is in perpetuity as he has planned it. It will be after his lifetime. I wanted to have a discussion with him to ask if when does he want the trust to terminate, or does he want it in perpetuity? Usually trust works are in perpetuity. Like the work of Umar ibn al-Khattab is a well. So during the time of the Prophet, a Jewish man owned a well, and he does not allow Muslims to take water from the well. So he said he wants to buy the well, but the Jewish man did not agree. He said, okay, so let's divide the well in two. Let me buy half of the well. It means that on and he agreed. He took a lot of money from him, and he agreed. He said, okay, on so days, you will take part of the well. You will have the use of the well, and on so days, I will have the use of the well. So on the days Umar ibn al-Khattab has the use of the well, all the Muslims will come and take water for free. So nobody is buying water. On the day the Jewish man has the use of the well, very few people will come and buy because he was selling it. He wasn't giving the water. And eventually he saw that on the day he was using the well, nobody comes. And on the day Umar will be using the well, everybody will come and get this water for free. So eventually he sold his half again to Umar. And then, so everyone was taking water for free, and then they started to plant dates. That's why one of the reasons why dates come from Saudi Arabia is that the dates for Umar, 1,400 years is still here. And then the Waqf is still here. He has bank accounts, he has schools, he has everything from that well, that particular well. So he was
So
feeding
the well is located in Saudi
people
Arabia.
with the date. Yes, in Medina. That's where the Prophet migrated to from Mecca. That's the city of the Prophet, they call it. So the Waqf is still here today, and then it still takes care of education. It has scholarships, it has hotels, it has schools, it has everything. And from that 1,400 years, it has bank accounts, it has investments from that time of the Prophet, peace be upon him. So this is the characteristic of a waqf. But then as we go on, we become a bit innovative and we say, okay, this waqf terminates probably after some years, even though there's still divergence of opinions that when you have a waqf, then you don't have anything, any interest in it. It belongs to that charitable purpose for which it is done. And but some people are a bit innovative with it. They say it terminates at so time, especially if it's a family work. You say this is a trust fund for the education of my children and their children's children up to maybe 4 generations, 5 generations. Then the last generation, the 5th generation will, if they want, share whatever it is, and if they want, they can still leave it. So next slide, please. So a donor can appoint a trustee and declare a trust over their asset for the benefit of the beneficiary. A trustee may be an individual or body corporate company. There may be a single trustee or multiple co-trustees. So this is where Imagine Africa comes in. So if a person wants to have a corporate trustee, then of course, which is very important, because you can't have your family as your trustee and then they twist and turn things to their benefit. But a trustee will now look at everything African. So it lives after you. Like if Felicia stops being the MD of trustees now, another person that comes. So it's institutional. It's not about a person. It's about the institution, and it carries on and on and on. That's why we advise people to register their trust with a corporate trustee, so you do not have any problem along the line. Not like a relation. Okay, if he dies today, so what? His children might even come and claim that, as far as they're concerned, it's their father's asset, and nobody can say anything about it if he hasn't said anything, for example.
Precisely, man. We always advise even most private trust clients that the ideal thing to do is to appoint a corporate trustee, because, like you said, even if Felicia is not in Imagine Africa trustees today, the trust runs, and it's not left to the whim of an individual. A relative, a lot depends on how the person feels after you're gone. Yes. But with a corporate trust, there's a trust deed that is set up, and the corporate trustee must adhere strictly to all that the settlor has indicated, his wishes and desires, her wishes and desires in the trust deed. So yes, precisely. Thank you, Mahan.
Thank you. So there are two pillars of the trust that must be fulfilled. That means that there has to be the SIGA, that's the structure of the trust in the form of a declaration, and then there has to be a trust deed. So upon the execution of the trust deed, the donor will no longer have any rights or ownership, like I had mentioned earlier. Usually, it's typically for an Islamic trust. So he won't have any rights or ownership to the asset or any income generated from that asset. So if you have given something in trust, maybe as a work, then that means you don't have any interest except for that charitable purpose which you had intentioned it to be. On the other hand, testamentary trust, that is the English trust made in a will. The wills can be revocable because the rules of Fara'id do not apply, for an English. So as earlier highlighted, the rules of Fara'id limit the testamentary freedom to 1/3 of a deceased estate, which can be used to bequest assets as gifts, charitable trusts, etc. I had mentioned that as a Muslim, you are entitled to give out as you wish your 1/3 to whoever you want. And that is where the testamentary capacity of a Muslim ends. When it says that you are entitled to, you have the freedom to do as you wish with your 1/3. I had already explained that in the previous slides. So you can give to your cousins, for example, to someone you've been looking after who is under your care, your wife's sister, for example, you can do that. You can give them anything around that 1/3. And that is also predicated upon the hadith of the Prophet, peace be upon him, where his companion said, I want to give everything I have for the cause of Islam. He said, no, you cannot give all. He said, okay, I want to give half. He said, no, you can't. He said, okay, I want to give 1/3. He said, yes, and only not more than 1/3. So based on this hadith, it has been accepted in Islam that you can give out 1/3 of your property. You have the freedom to do as you like with your 1/3, but the rest you do not have any freedom to do as you want after you're gone. So the only freedom you have with your asset is when you are alive to do as you want. That's why we say you can use the opportunity during your lifetime to manage your assets, to create trust, charitable trust, and do whatever you want. But when you're gone, then that 1/3 is the only one you have the freedom to do as you wish with. So such testamentary trusts are only effective upon the death and must be attested in the will and cannot also be taken to an existing heir. Like I said, that you can only do this, they can only take effect when you're gone. And the heirs, your Quranic heirs, are not entitled at all to your 1/3. And so you can be able to say that during your lifetime, I have given this child this, I have given this child this. But after you're gone, then it's up to um, how the Quran wants you to divulge your assets, and it must be done. You have no right over it. This is how far I can go. This is very extensive. Every one of it is an area on its own. If we go on and on and on, it will just be almost inconclusive. But thank you very much, everyone. If you have any questions now, I'll take questions. Thank you. I hope I have not bored you.
No, in fact, it's been very interesting and extremely enlightening, I must say. The interesting aspect that I see is how the pillars are very similar. The pillars of Islamic trust are very similar to the mainstream English common law trust that's the mainstream that
That's
we practice.
because they copied. That's because
I've told you that's we'll discuss that offline. So one question that an attendee has sent is how does the 1/3 the question is, can that 1/3 also be applied to, I think how you put it was that there are some hereditary and mandatory Islamic heirs, right? But that 1/3 can, in addition to what the mandatory heirs can access or can be devolved to, can they also access a portion of the 1/3, or they're strictly excluded from it?
So they're strictly excluded, but there's an exception to that rule. Some jurists are of the opinion that if all the family members sit and say, yes, we have agreed, because sometimes you see that a father leaves and then one of the children will be doing a lot for him, doing work and all that. So he will say, okay, when I die, you will be entitled to so assets. Usually, if the other heirs do not object and all agree that, yes, it's okay for him to have, then he can have it. But otherwise, strictly no heir is allowed to inherit from that 1/3. It's strictly made for non-heirs, yes.
Thank you. Another question that we've received is, excuse me, are non-Muslim beneficiaries to be included under an Islamic will? And what are the modalities of that? How would it look like? can non-Muslim beneficiaries benefit from an Islamic will? And what are the modalities?
So a Muslim, a non-Muslim cannot inherit from a non-Muslim. So even if that non-Muslim is the heir to a Quranic heir to the deceased, the only other way will be under that 1/3, or during his lifetime, he gives whatever he wants to give to that non-Muslim. You can gift whatever to whoever you want, a Jew, a Christian, anyone, but your heirs, a non-Muslim cannot inherit a Muslim, and vice versa under Islam. Yes.
Wow, that's interesting.
Yes.
So interesting. Then another question is corporate trust, a corporate trustee recognized in Islamic trust?
Absolutely, absolutely. Because coming together, writing a will, putting things in writing, all can be done formally. And being formal means that you can engage someone who has a specialty in that area. And that's where a trustee comes in. So don't worry, you are allowed.
Thank you so much, man. Most grateful.
Thank you.
Yeah, there's one more question. Sorry. Okay, the next question is, who conducts the credibility test, and what qualifies one as being credible to dispose of his or her assets while alive? Let me repeat it. Who conducts the credibility test, and what qualifies one as being credible to dispose of his or her assets while alive?
So if I'm a 90-year-old woman, and then now I tell you, oh, I want to give you, let's say I have told you to go and get this book for me. And when you bring it, I'll be like, oh, when did I say that? I never said.
I said.
Yeah, so that brings your age is playing its games on you. Then it's telling you things that are not correct. So you're unstable, from your interactions with your family and friends. So they just laugh you off as someone who, oh, it's old age that is worrying him. So during that old age, you will now say, okay, please, I have given Umahani this whole estate. God, I wish it's true.
Well, from the rich auntie.
And then bring Felicia. Felicia, come and write this this thing. You are my trustee. Come and write. Umahani I have given her because she has proven to be very good to me. Oh yeah, I've given her. Then the person dies tomorrow. A 90-year-old man, for example. So it has to be doctors and to certify that and all that. And of course, his relations. Was he in his right state of mind? Is he hallucinating? Does he talk off point? So these are things that people close to you will attest to first before you pass the test of a medical doctor. It will be established first. I hope that answers your question.
Yes, I hope you can still hear me. There's power outage here, but can you hear me? Okay, so that means that this one.
Yes, I can.
I think we can still take one more question. There's a question which says, thank you for your presentation. Regarding the adopted child who was to be shared part of her adopted parents' property.
Yes.
Thought Islam is opposed to adoption. Is opposed to adoption. Please comment.
So Islam does not allow adoption. Everybody bears his father's name. So there's a prophetic, there's an incident that happened during the time of the prophet, peace be upon him. And that incident had been able to bring out in the open that your child is your child, the person that is not your biological child is not your child. So this has happened. There was a time during the wars in Islam, the Prophet had gone to war, and of course, the spoils of the war were people captured. So they captured some people as slaves. Of course, they were living with the Prophet, peace be upon him. And then one of them is Zaid ibn Tabit, that's his name. So Zaid, the Prophet, peace be upon him, loved Zaid like his own child. And then he treated him as such. So Zaid's parents came from Medina to come and pay a ransom and take their child away. But Zaid said he is not going to go with his parents. He wants to stay with the Prophet, peace be upon him. So the Prophet now said, okay, he was very happy. He had already loved the boy. He said now Zaid is his adopted son. So they used to call him Zaid ibn Muhammad. That's Zaid, the son of Muhammad, like the Arab called their parents and children. So God, in His infinite wisdom, sent a revelation to the Prophet that Zaid should not be called Zaid ibn Muhammad's name. And so the Prophet now reversed his name to Zaid ibn Tabit because those were instructions from God. And then eventually God, again in his wisdom, saw that the Prophet still treated him as his child, even though he didn't
answer, he wasn't taking his name.
He didn't answering his name. So it took years for God to be able to put that message through to the Prophet, peace be upon him, and to all Muslims. So Zaid grew up and he married the cousin of the Prophet. Her name is Zainab. So Zaid married Zainab, but Zainab became very arrogant, her being from the lineage of the Prophet and him being a slave and all that. So there were complaints every day, there were fights every day, and then eventually they got divorced. After they got divorced, in Islam allows you to marry your cousin. So God directed that the Prophet will marry Zainab. And from history, that was the most difficult part in the life of the Prophet, peace be upon him. That was the most difficult decision he had to take. And Zainab, he married the Prophet, peace be upon him. And the Prophet, even though that was the most difficult thing for him, he accepted that this is what God decreed. And so it was simplified very simply that, of course, you can't marry your son's wife. So it says that Zaid is not the wife, is not the son of the Prophet, peace be upon him. So that very explicitly explained that your adopted child is not your child, and he's not allowed to inherit you as a Quranic heir, but then you can give him whatever you want during your lifetime, or you can give him from the 1/3, upon which you have testamentary capacity to do.
Thank you so much. I hope that answers that question. Another question, questions keep popping up. We have to stop.
I
Another question.
Yes.
Another, let's take it as, should that be the last question? Is there any scriptural provision for Islamic trust and will in Islam?
Yes, I had mentioned that a companion of the Prophet had said that you cannot go 2 days without a will. If you have, that is, you have to leave a wasiyah, you have to leave a will. So Islam, even in the Quran, had mentioned that you must leave witnesses. You must call in witnesses in case you want to take decisions upon your property or your testamentary capacity and all that. The Quran had mentioned that.
Thank you, Mahani. I'm afraid we can't take time is actually up. I'm afraid we can't take any more questions. And on behalf of the attendees and Imagine Africa trustees and indeed Imagine Africa Group, would like to say a very big thank you, Mahani. Thank you for your time. Thank you for, I've learned quite a bit on Islamic law, especially trust. And my key takeaways are the fact that a corporate trustee is recognized in Islamic trust and Islamic law, and that in fact to put affairs in order, it's ideal to appoint a corporate trust if you want to set up a trust, and even for your wills. Thank you so much, Mahani.
Thank you. Thank you for having me. Thank you.
And so at the beginning, bye, Mahani. We couldn't explain or give a quick talk on Imagine Africa Trustees. So I'll just do a quick one before we sign off. Imagine Africa Trustees is a subsidiary of the Imagine Africa Group. Our services cut across public, corporate, and private trusts. We are duly registered by the Securities and Exchange Commission, and we have private trust products, of which testamentary trust that Mahani has mentioned and estate planning are part of our services. And so our details will be put on the screen, and we're on Instagram, we're on Twitter, we are situated at 20. Can you imagine? I just had a brain fact. 21, 27. 27 body law. That's our physical location. But you can meet us up anywhere, online and physically. Thank you so much. Bye.
Thank you. Bye.
Bye, Mahani. See you soon.
Bye.